Allgeyer versus Louisiana. Now, if you've watched my Lochner versus New York 2-minute summary, you'll notice that I made a mistake. I said that the Lochner v. New York case marked the beginning of the Lochner Era. It didn't mark the beginning, it gave it its name. Lochner was decided in 1905. Allgeyer versus Louisiana is the actual beginning of the Lochner Era, and it was decided in 1897, about 8 years earlier. But basically, both cases use the concept of substantive due process to find within the due process clause of the 14th Amendment an economic liberty, a right to pursue happiness, a right to pursue your occupation and your calling in life. And this right can't be abridged by government regulation unless the government can show a reason, basically. And both decisions were written by the same justice, Justice Rufus Wheeler Peckham. So both of them contain sort of the same underlying philosophy. Only in this case, in Allgeyer's case, Allgeyer's pursuit of happiness was that they were cotton merchants, and they were insuring their shipments of cotton to Europe through a company in New York. Now maybe New York or maybe Louisiana was upset that Allgeyer was using a New York insurance company, but nevertheless they tried to apply Louisiana regulations on insurance to Allgeyer and said you can't do this. Well, Justice Peckham wrote a decision saying that this regulation as applied to Allgeyer is unconstitutional. It violates their 14th Amendment right under the Due Process Clause to pursue happiness, to pursue their occupation and their calling as cotton merchants and all the attendant things that would come with that, such as entering into contracts. So this marks the beginning of the Lochner Era.